Welcome to a new deep dive from Talk Testimonies. Today, we're jumping into a really significant Supreme Court case, Air and Liquid Systems Corp v. DeVries.
That's right. This one dealt with product liability and specifically, well, the duty to warn.
Yeah, focusing on manufacturers of what they call bare metal products, things like pumps, turbines,
Exactly. And the big question was, do these manufacturers have to warn about dangers from asbestos products made by other companies?
Even if it was totally predictable that their equipment would be used with that asbestos stuff.
Precisely. And spoiler alert, the Supreme Court ultimately said no, they didn't have that duty.
Right. So today, let's unpack how they got there. We need to look at the arguments on both sides.
Absolutely. The oral arguments happened back on October 10th, 2018. This case really digs into some fundamental tort law concepts, especially within maritime law.
Okay, so let's dive in. What was the main thrust of the argument from the manufacturer's side, Air and Liquid Systems, and the others?
Well, their core argument was pretty straightforward, really. They said the normal rule in tort law, which they argued should apply in admiralty law too, is that you're liable for your own product's problems.
Not for problems caused by someone else's product, even if you knew they might be used together.
Exactly. Foreseeability alone, they argued, just isn't enough to create a duty to warn about a third-party product.
They had some analogies for that, didn't they? I remember something about tires.
They did. Like a tire maker shouldn't be liable if their tire is put on some faulty multi-piece wheel made by someone else and it explodes.
Even if they knew their tires might end up on those wheels.
Right. Or a plane manufacturer not being liable if a passenger gets a blood clot from a seat installed by the airline, a third party.
So just because you can see it coming
doesn't make it your legal responsibility to warn about that specific danger. They argue the duty rests with the party best placed to control the risk.
Which they said was who? The asbestos makers.
Yes, either the asbestos manufacturers themselves or, interestingly, the Navy, because the Navy often specified the use of asbestos.
And they also worried about too many warnings.
Yeah, the overwarning problem. Their point was, look, if we have to warn about every possible danger from every third-party product used with ours,
people will just tune it out.
Exactly. Warnings lose their effectiveness. It could actually make things less safe, paradoxically. Plus, it creates massive confusion for manufacturers. What exactly do we want about?
And that connects to their point about vague terms like required or specified use.
Precise. They argue those terms are too fuzzy. What does required really mean in this context? Does it mean absolutely impossible to function without it, or just, the best option at the time?
Creates unpredictable rules.
Very much so. They wanted a clearer line.
Did they try to distinguish their products from situations where a manufacturer does have a duty regarding a third-party item?
Yes, they did. They drew a distinction. They said, look, our machines aren't like, say, a flashlight specifically designed to puncture a battery and cause a leak.
Okay.
Their point was their machines didn't somehow uniquely change the asbestos or make it more dangerous. The asbestos was dangerous on its own.
And the practical problem of multiple warnings, if everyone had to warn.
Right. Imagine a complex system like a ship's engine room. You'd have the pump maker warning, the valve maker warning, the turbine maker warning, all about the same asbestos gaskets or packing.
It could get messy. Conflicting warnings, maybe.
Potentially confusing, definitely inconsistent, not helpful.
And their final point was basically, hey, look around. This isn't how tort law usually works.
Pretty much. Outside of these specific asbestos cases that had bubbled up, they argued there's really no general legal precedent holding manufacturer A liable for injuries caused solely by manufacturer B's product just because they were used together.
Like the drywall maker doesn't warn about lead paint someone else applies later.
Exactly. Or the toy maker doesn't usually warn about batteries leaking. That duty typically falls on the paint maker or the battery maker.
Okay, that lays out the manufacturer's case clearly. Let's switch gears. What about the respondents Roberta DeVries and the plaintiffs? What was their main legal hook?
Their argument was really grounded in the Restatement of Torts, Section 388.
Remind us what that says.
Basically, it imposes a duty to warn if the ordinary use, or crucially here, the maintenance of your product is going to cause a known harm.
And they argued the maintenance did cause harm here.
Yes. They said the routine maintenance on these pumps and valves, things like scraping out old gaskets, cutting new ones, that process aerosolized the asbestos, it turned it into dangerous dust.
So the act of maintaining the defendant's machine created the hazard.
That was their key point. It wasn't just that asbestos was present, it was that the machine's necessary upkeep released the dangerous fibers, a distinct harm, they argued.
Did they bring up the maritime law context, the sailors?
They did. They invoked the idea of special solicitude for sailors that exists in admiralty law. Given the known history of asbestos exposure on ships, they argued this principle should support finding a duty to warn.
And how do they counter those analogies the manufacturers used, like the paint or the batteries?
They tried to distinguish them. They argued this wasn't just a case of foreseeable combination. They said these machines often functionally required asbestos parts, especially internal gaskets and packing, to work properly.
So not just an optional add-on, but integral.
Integral, yes. Necessary for the intended function, particularly under high heat or pressure conditions common on ships.
And they flipped that flashlight analogy back, right?
They did, quite cleverly. They said, imagine a flashlight designed to puncture a battery as part of its normal function. Wouldn't the flashlight maker then have a duty to warn about the leaking battery, even if they didn't make the battery?
Implying the manufacturers here designed a system where asbestos interaction was inevitable.
Exactly. The danger, they argued, arose directly from the machine's intended operation and maintenance cycle.
How did they handle the ashtray hypothetical?
They distinguished it by saying an ashtray has many potential uses, or no use at all. But these machines, they argued, were specifically designed to use components that, at the time, often contained asbestos.
What about the Navy's knowledge? Did that excuse the manufacturers?
The respondents argued no. They said even if the Navy knew about asbestos generally, that didn't absolve the manufacturers of their own duty, especially if the manufacturers directed or required asbestos use in their manuals or specs.
And they kept highlighting those internal parts, the gaskets and packing.
Constantly. They emphasized that these weren't just external things added later. Often, the machines were shipped with asbestos components, or the manuals specified their use for replacement, and the degradation of these parts during maintenance was the core issue.
Okay, let's talk about the actual oral argument. The justices must have had a lot of questions. Any key moments?
Oh, absolutely. Justice Ginsburg jumped right in, questioning if it made a difference that these products were, well, essentially useless without the asbestos parts.
That seems like a critical point.
It really does. And Justice Sotomayor explored that further with the concept of an integrated product. Was the harm caused by the asbestos as shaped and used by the petitioner's products?
Interesting framing. What about the Chief Justice?
Chief Justice Roberts pushed back on whether admiralty law should have a special rule here, distinct from general tort principles. He also questioned that gasoline in a car analogy, suggesting maybe using asbestos was inherently unsafe in a way fueling a car isn't.
And Justice Breyer. He often focuses on the restatements, right?
He did. He homed in on Section 388 and negligence. He asked, if a manufacturer directs you to use asbestos, isn't that potentially negligent?
Makes sense.
And he brought up replacement parts. If it starts with asbestos, shouldn't you foresee it will be replaced with asbestos?
What about Justice Kagan? I recall she can be quite direct.
She really pressed the manufacturers on fairness and efficiency. Why shouldn't you have a duty to warn if you're telling people to use this dangerous thing with your product? Where's the fairness in avoiding liability then?
Good question. Justice Gorsuch. He sometimes focuses on predictability and clear rules.
Yes, he questioned the foreseeability standard used by the lower court, worrying it was too broad. He also brought up the overwarning concern and used those ashtray and flashlight hypotheticals to probe the limits of the duty.
Justices Alito and Kavanaugh also chimed in on those.
They did. Justice Alito questioned if the bare metal product itself was dangerous at all, and Justice Kavanaugh used the flashlight battery and ashtray tobacco examples to explore this integrated product idea. Does it matter if the component ships with the product? Is its use inevitable?
Were other defenses like the government contractor defense discussed much?
They were mentioned, things like superseding cause too, but they weren't the main event. The core fight was really about whether this fundamental duty to warn existed in the first place for these third-party products.
Okay, so now let's put on our hypothetical 10th chair hat. If we were deciding this case, what's the takeaway? What's the tension here?
Well, stepping back, it really is a tough one. You've got this bedrock tort principle. You're responsible for your product. Extending that easily leads down a slippery slope. You don't want endless liability.
Right, the manufacturer's main point.
But then you have this specific situation where the defendant's products didn't just happen to be used with asbestos. Their argument is that the products were, in many ways, designed to use it, or at least their maintenance required interacting with it in a way that foreseeably released dangerous fibers.
And the maritime context adds another layer.
It does. That special concern for sailors, who we know suffered greatly from asbestos exposure, carries weight. It pushes against a purely formalistic application of the bare metal doctrine.
So maybe focusing just on the product as sold the bare metal is too narrow.
That's the argument. Perhaps you need to look at the product's entire intended life cycle. If the design and the manufacturer's own maintenance instructions inevitably lead to hazardous exposure from a necessary component, well, maybe the analysis needs to be different.
It seems the key is how integral the asbestos was.
I think so. Was it just one possible component among many, or was it functionally required for the product to operate as intended, especially in that specific environment? And did the manufacturer's product itself, through its operation or maintenance, create the hazard? Not just the asbestos sitting there, but the machine acting on the asbestos.
So a possible path forward, maybe a narrower ruling.
Perhaps. Instead of a broad rule saying manufacturers always or never have a duty for third-party parts, maybe the focus should be narrower. Like if a manufacturer's product inherently requires a specific hazardous component for its core function, and the normal use or maintenance of that product directly causes the hazard to be released, maybe then a duty to warn arises.
That sounds like threading a needle.
It is. It would try to capture those situations where the manufacturer is more directly implicated in creating the risk through their own product's design and intended use, without opening the floodgates to liability for every foreseeable combination of products.
It acknowledges the manufacturer's role in creating the hazardous system, not just selling one part of it.
Exactly. It's about their contribution to the mechanism of injury, going beyond just placing the initial product into the stream of commerce.
Well, that brings us to the end of our deep dive on Air and Liquid Systems Court v. DeVries, a really complex intersection of product liability, foreseeability, and maritime law.
It definitely shows how hard it can be to apply older legal doctrines to harms like asbestos exposure, which happen over long periods and involve multiple products.
And it leaves us thinking about that core question. Where should the duty to warn stop? How responsible is a manufacturer for harms related to necessary but separate components?
It's a critical question, with huge stakes for manufacturers and, of course, for people potentially exposed to hazards. What do you think? Where's the right balance?
Something for our listeners to definitely ponder. We encourage you to keep exploring this fascinating area of law. Join us next time for another insightful deep dive.